Hi again, everyone. This is Marc Movsesian. I'm the director of the Center for Law and Religion at St. John's University. I'm joined by my colleague and friend, the Center's Associate Director, Marc DeGirolami, for another episode in our podcast series, Legal Spirits. This is a podcast series that looks at issues and cases in law and religion. If you'd like to hear past podcasts, you can find us at Legal Spirits on iTunes, or you can go to our website, lawandreligionforum.org, and you can find past podcasts there. Well, today, Marc, we're going to talk about a recent Supreme Court opinion from last month in which the court denied cert in a very interesting case involving a high school football coach who wants to pray after each game at the 50-yard line. This is a Ninth Circuit opinion. The Ninth Circuit held that the school could forbid the coach from praying at the 50-yard line. The coach sought cert at the U.S. Supreme Court, and the Supreme Court denied cert, but there was a very interesting statement by Justice Alito, joined by three other justices, which actually suggests that at least four of the justices on the court are now willing to reconsider some important religion clause jurisprudence. So that's what we're going to talk about today. The case is called Kennedy versus Bremerton School District. It comes out of Washington State. So, Marc, you want to tell us the facts of the case?
Yeah, sure. So, the facts involve as you say, a football coach who actually had engaged. The conduct in question involves kneeling at the 50-yard line and engaging in prayer on his own. But it seems like from the facts that there's kind of a long history here of the coach engaging in various kinds of prayer or kind of motivational speaking on behalf of the team. Is that right, Marc?
That is right. And I think we should point out that the coach, whose name was Kennedy, said that his religious beliefs required him to give thanks for the players' accomplishments and the game and the teams through prayer on the field after the game. So that's why he said he really had to be there at the 50-yard line praying. For him, that was a matter of his religious beliefs. His religious beliefs required him to do that. We should say he didn't ask anybody to join him. He didn't require anyone to join him. But over time, players from his own team, the Bremerton High School team, and other teams joined him. So, the district court concluded there might have been some subtle pressure there, but we should point out he wasn't requiring anybody to join him in the prayer.
Right. And the other thing to point out is that this was not done pursuant to any kind of official school policy. In fact, what ended up happening was that he got in trouble with the school district, and the school district pointed out to him various provisions of his employment contract. As many of these contracts do, they talk in very broad language about the responsibilities of teachers. They entrusted Kennedy to be a coach and a mentor and a role model for student athletes, to exhibit sportsmanlike conduct, that his job requirements were or involved supervisory responsibilities, and to adhere to the district's administrative regulations and policies and so on. So the nature of his employment was framed in these kinds of broad hortatory terms, but there was certainly there was nothing in it that either required or even urged him to engage in prayer practices of this kind.
Right. So after several episodes of this, he'd go out to the 50-yard line, he would take a knee and pray, and kids would join him, and sometimes members of the other teams would join him. The school district told him not to do it anymore, and they gave him two reasons. They said, first, you're neglecting your responsibility to supervise what the players are doing during the time when you're on the field with them. In other words, when you start praying, you're not doing your job and you can't do this anymore. And second, they said that his actions in praying at the 50-yard line would lead a reasonable observer to think that the high school was itself endorsing religion. And that would be a violation of the Establishment Clause because, look, they said you're on the field, you're under the game lights, you have high school logo on your clothing, you're in front of an audience of people who've come to see the football game. The people could think that we endorse what you're doing, and that would be an Establishment Clause violation.
Yeah, and I just want to note two things. Number one, that the concern was framed not necessarily as an Establishment Clause violation. It was framed as the perception of some people that we might be violating the Establishment Clause, which I think is going to be something important that we're going to get to a little bit later when we talk about one of the concurrences. That's number one. The second thing was that even though, and I think you're right, Marc, that this is framed by the district as involving religion clause issues, the claim that he brought was a free speech claim.
Right.
Yeah, go ahead.
No, sorry, Mark. So what about the free speech claim?
Well, so as you know, or as I think we may have talked about, he was fired eventually,
right.
and he brought a First Amendment free speech claim, arguing that he was fired in retaliation for exercising his free speech rights. And basically what happened to that claim was that it was rejected by the panel. The Ninth Circuit held that the coach was speaking as a public employee rather than a private citizen. So it didn't even reach the question whether the school district's interest in avoiding the appearance of endorsing religion was strong enough to overcome his free speech rights. And that's because, and we're not going to spend too much time on this feature of the case, but it's at least worth alerting our readers to it, that under Supreme Court rules, and in particular a case called Garcetti versus Ceballos, when public employees make statements pursuant to their official duties, when a teacher speaks in a classroom, for example, they're not speaking as citizens for purposes of the First Amendment. And then there's a kind of functional test for determining whether somebody is speaking pursuant to official duties. You compare the job functions and the context of the speech and so on. And basically what the panel said, look, when he's kneeling and praying at the 50-yard line immediately after games, in view of students, he is acting pursuant to official duties, and therefore ordinary free speech rules don't apply. The district has a lot more control over the content of what he can and can't do. Furthermore, he didn't want an accommodation. He refused an accommodation to pray after everybody had left the stadium, which was apparently the accommodation that was offered him. And that led the panel to conclude even more firmly that this is really speech in the context of one's official acts as a public official. So that's why the court held that the free speech claim failed. Justice Alito, and joined by three other justices, didn't really like the breadth of the way that the Ninth Circuit read Ceballos and said as much. Justice Alito didn't like much about the Ninth Circuit opinion at all and was quite clear about that. But that's really the nature of the speech claim.
Okay, good. That's the speech claim. But as we said at the start of the podcast, that's not where we're interested in it. And actually, that's not why many commentators have been interested in it. They're interested in this case because of what happened when Kennedy tried to get cert at the Supreme Court to review his case. Last month, the Supreme Court denied cert, so they're not going to hear his case. But there was a very interesting statement by Justice Alito, joined by Justices Thomas, Gorsuch, and Kavanaugh, saying, well, I agree that we shouldn't hear this case.
Interesting, by the way, Mark, that Chief Justice Roberts did not join.
Yes, once again, Roberts did not join, which is showing how maybe he's positioning himself as the center of the court now. But what Justice Alito and these three other justices said was, well, we should deny cert because of the factual difficulties in the record. It's not quite clear exactly why the high school fired Kennedy. Remember, they gave two different reasons. One of them was he's not doing his job because he's not supervising what the players are doing while he's praying, and his job is to supervise them. And the other is what he was doing gave the appearance of an Establishment Clause violation. And Justice Alito said, well, we just can't tell on this record what the claim was, and it's a standard thing at the Supreme Court. They won't grant cert to review a case if there are factual problems. But in the last paragraph of the opinion, Justice Alito said, something, even though Kennedy has brought a free speech claim, actually, he does have a free exercise claim as well, which he hasn't raised with us, Justice Alito said, probably because of a case called Employment Division versus Smith, which would make it very hard to bring a free exercise claim, and also because of another case involving Title VII and religious discrimination that we don't need to get into, which would also suggest that employers don't have to accommodate employees' religious practices in this way. And then Justice Alito said, last sentence of his statement, in this case, we have not been asked to revisit those decisions, which court watchers immediately saw as an indication that, well, if you do ask us to revisit those decisions, we'll be happy to do so.
Yeah, I think that's right. And that's a pretty strong suggestion on its own. And I think it's fair to say that Justice Alito, as a circuit judge, certainly Justice Gorsuch as a circuit judge, I'm not as sure about Justice Kavanaugh as a circuit judge and where he comes down. Now, perhaps you have some knowledge about this, Mark, but where he comes down on the issue of the Smith, of employment division versus Smith, and which approach he favors. But certainly those other two justices are no fans of the approach that Justice Scalia laid out in employment division versus Smith. You know, the key cases in the Third Circuit when Judge Alito was on it are his cases where he really does everything that he can to get out from under the Smith rule. And so in some ways, it's not surprising that you see this sort of solicitude on the part of Justice Alito for revisiting this issue.
Okay, so let's talk about this. If people are correct, and I mean, I think people are right to think this is a serious signal from Justice Alito about this, let's talk about this a little bit. So first, let's talk about the Smith case and what the holding is, and what would possibly happen to Kennedy's claim under Smith.
Okay, so the Smith case involved a claim by two Native Americans that were denied unemployment compensation benefits after they were terminated for drug use. So they were terminated for drug use and they were denied by the state of Oregon unemployment compensation benefits. And they claimed that the denial violated their free exercise rights because the drug in question was peyote. And they claimed that as part of their Native American religious practice, they needed to ingest, I believe it is, peyote to fulfill various requirements, ritualistic requirements. And the court ultimately held that they were not entitled to a free exercise exemption, to a free exercise claim under these circumstances, because when you have a a neutral law of general application, a law that A, doesn't discriminate against anybody else or any particular religion, and B, that is applied generally, that doesn't have all kinds of exceptions or particular carve-outs showing favoritism toward or against religion, then that law is going to be constitutional, notwithstanding the burden that it might impose on particular religious practice.
Right. So that's the Smith case, Mark. And so how do we think Coach Kennedy would fare under Smith? I guess he'd be claiming that he needs a religious accommodation to allow him to practice his religion by praying on the 50-yard line, even though he's on the job and is supervising students. And I guess he'd lose under Smith, right, Mark?
Well, probably, or he might lose. I mean, it depends on the nature of the policy at issue, and it's not clear exactly what the policy is. If the idea is that anybody can, while on the job, say anything that they want except for religious things, or express themselves in any way that they like except for religious expression, well, that might be a little bit more problematic, although, as I say, the relationship between a speech claim here, where there is considerable latitude allowed to the district, and a religious freedom claim in this context isn't exactly clear to me. I'm not sure how that would shake out. However, I would say that it's certainly more problematic if the only thing that he can't do is pray, but he can do anything that he wants otherwise. In other words, if the policy of the school is implemented in such a way that other sorts of non-job related expressions are perfectly appropriate. I don't know, advertising for his favorite cookie club or something like that, right? He can do that as much as he wants on the sideline, but he can't do this. Well, then even under Smith, I would think that might be constitutionally problematic.
Yeah, so I think what you're saying is, Mark, is that even under Smith, if the law doesn't seem neutral with respect to religion, he might have a constitutional claim. And I guess if he could show that they let people do other kinds of motivational things at the game and those people don't get in trouble. The only one who gets in trouble is me when I say something religious as part of a motivational thing. Yeah, maybe he could say it's not neutral. So maybe even under Smith, he might be able to prevail. So what would happen in a case like that if Kennedy were to claim, I want a religious accommodation and the old rule applies, or indeed the rule under RFRA applies?
Right. So let's assume that the rule under RFRA applies, and we'll get to in a moment to what that rule is. There's a question about the interpretation of Smith under circumstances where it's violated. Under one approach, you kind of revert to the old rule, which is a balancing test. Under another interpretation, the government practice is unconstitutional, full stop. And so there's no balancing that happens. And that issue, let's set that issue to one side. Let's assume that what happens is that one reverts back to the balancing approach of cases like Sherbert versus Werner, or as you say, the RFRA test, which requires a showing of a substantial burden on the part of the plaintiff, substantial burden on religious exercise, and then the burden shifts to the state to show that the burden imposed, that there's a compelling interest for the burden imposed that is being achieved by the least restrictive means. So I think certainly the substantial burden factor would be satisfied here. The question would really come down to whether there is a compelling interest, whether the district has a compelling interest to impose this particular policy or this particular rule on this coach in this context.
Right. And so the district, as we've said a couple of times now, gave a couple of different reasons here, which I guess they'd say is compelling. One of them is supervising everyone on the field. And, if you're praying at the 50-yard line, you can't really be supervising people. I suppose that's a compelling interest, but then
that
the question
seems like a compelling interest to me, right?
It does seem like a compelling interest. Yeah, it does. Then, of course, the question would be whether preventing him from praying is the least restrictive means of achieving that interest. And, maybe there are other coaches around, maybe there are parents there, maybe, there's not really a danger of a lack of supervision. If somebody does something, he can stop praying. So that's one set of issues. But I think, Marc, I don't know what you think about this. I think really the more interesting issue here would be the second justification. And that is, if we assume that we have a compelling interest test applying here, so that the state can restrict Kennedy's praying if it has a compelling interest that justifies it in doing so, well, then one possible compelling interest is the one the school gave him, the alternate one the school gave him, namely that they are trying to avoid the appearance of an Establishment Clause violation. And actually, in the Ninth Circuit, Judge Smith wrote a concurrence all about this. And he said, in fact, the state does have a compelling interest in doing so, because allowing Kennedy to pray like this would lead an objective observer to see that the school had endorsed religion.
So this is very interesting, and actually I want to connect this justification to a number of other issues that have been going on in Establishment Clause. There's a sort of a crossover of Establishment Clause free exercise cases. And the ones that I have in mind in particular are sometimes described as issues of equal access. So this is a case out of New York City where you have public school classrooms that were made available for use by private groups and organizations during after school hours. And the Supreme Court at one point had held, look, government cannot single out religious viewpoints for exclusion from that kind of use. But there was a group called the Bronx Household of Faith that applied for access to public school space on the same terms as everybody else and was denied access by the City Board of Education. Why? Well, because the board said we can exclude religious groups that engage in worship on the ground that allowing those groups into classrooms might violate what it called the non-endorsement principle. So the argument is the state has an interest in appearing not to violate the Establishment Clause, even if it isn't actually violating the Establishment Clause. And it appears to violate the Establishment Clause when, for example, it accommodates a religious group or a person or an organization, whether or not on equal terms with non-religious groups. So this issue, it's an interesting issue in as much as it's kind of what I've called in an essay, Establishment Clause bloat. A court doesn't actually have to hold that a particular accommodation would violate the Establishment Clause. All it has to do is to say, look, because the state has a compelling interest in seeming like it's avoiding any Establishment Clause problems, we're not going to accommodate your interest. So that's a little bit like what's happening here, it seems to me.
Yeah, that's a nice point. So that would be sort of that one remove. It's not even a violation, as we want to avoid appearance of a violation. And
correct. It doesn't have to get to that point to adjudicate that issue.
So I guess in a case like this, what the school board would say is, look, somebody might think, that an objective observer could see the prayers that Justice Kennedy, he's not his coach, Assistant Coach Kennedy, I'm confusing titles. An objective observer could see Coach Kennedy's prayers as being endorsed by the school, which could be an Establishment Clause violation. Judge Smith said, look, the coach is is, saying these prayers in front of everyone who's come for the high school football game. He's wearing the logo of the high school football team. All the players are around him. It would be very easy for somebody to think, as a result of this, that the school had endorsed the religion. Now, I think there's a weak point here. I want to talk, Mark, about another case involving prayers at football games, and that's the Santa Fe case back from 2000, because that's a case that Judge Smith in the Ninth Circuit spent a lot of time talking about. In the Santa Fe case, students were leading prayers before high school football games. The students were selected by the school. The school actually spent some time giving guidelines, general guidelines for what the students could say and couldn't say. And in 2000, by a vote of 6-3, the Supreme Court said that that practice violated the Establishment Clause. Why? For two reasons. One, again, using the endorsement test, the court said a reasonable observer could look at this situation and think that it wasn't just the students who were praying, it was in fact the school that was endorsing the act of the students praying. And that would be a violation of the Establishment Clause, because under the endorsement test, the state cannot do anything that would suggest that it was endorsing religion. That was one reason. And the other reason was a kind of informal coercion argument. This comes out of a case called Lee versus Weissman, and from 1993. And in the Santa Fe case, the Supreme Court said that, there's immense social pressure to attend high school football games. People really don't think they can stay away. And in that setting, there's just too much pressure upon impressionable students to join in the prayer. And so for those reasons, the prayers at the high school football game violated the Establishment Clause.
Yeah, so I think those are two interesting and very different kinds of rationales. I think that the first rationale, at least in this case, is not as powerful as it was in Santa Fe, because what this coach was doing is, as we said at the beginning, is not pursuant to any kind of official policy. His school's not selecting him to give us a prayer, or there's not a kind of a complicated history about the way in which student selection and prayer go hand in hand with school policy, as there was in Santa Fe. This is an activity that goes counter to what the school wants. In fact, the school is objecting to it. So that's one difference for sure.
Right. I agree with you, Mark. And, Judge Smith made the point in the concurrence in the Ninth Circuit that Santa Fe really governs this case. I don't think so, for the reason that you state, and also for another reason, which is really, if you say that the guy going out there and praying, the coach going out there and praying on his own, could be a violation of the endorsement test, because the mere fact that the school allows him to do it suggests that they are endorsing religion, well, that's extremely broad, much broader than in Santa Fe.
Right. Well, so this is part of the problem of this issue of bloat, right? So the one counter to the position to the view that we're talking about here is that, well, look, there has to be a certain amount of space within which people operate. Sometimes this is called the play in the joints between what is prohibited by the Establishment Clause, required by the Free Exercise Clause. There's got to be some space in there for people, organizations, the government to be able to operate without violating either of these principles. And that's certainly understandable. The school might come back and say, look, we're not taking a position about whether what the coach is doing actually violates the Establishment Clause. But you know what? We don't like it. We don't want that. We don't know about its constitutionality or not, but it's not the kind of thing that we want going on at our school. And to me, I think that that's certainly a tenable position. It's that by the time it gets to the courts, the question about whether something is a free exercise violation or instead something is just a particular activity is or government rule is just something that the government can do that's playing the joints, it seems to me that there's less and less space for those two to coexist. In other words, that they're naturally going to be bumping up against one another, particularly as schools or the government becomes more aggressive in not wanting religion to be part of whatever is in the public view or in the public square.
Yeah, of course, that's very interesting, Mark. Of course, if that's what the school says, is we just don't like this sort of thing, then I think they're into the non-neutral stuff again, right? We just, you can make all kinds of, motivational speeches, but if you say a prayer, then you can't do it. That sounds like a violation even of the neutrality principle under Smith.
Right, or maybe they don't say we don't like it. Maybe it makes people feel uncomfortable. It's not inclusive. It's
Yeah.
not sufficiently diverse, right? They could talk about it basically saying we don't like it for various sorts of officially neutral sounding reasons.
Okay, and now the other possible reason why this was a violation of the Establishment Clause was the informal coercion point. As I say, this goes back to a case called Lee versus Weissman, written by Justice Kennedy in 1993, in which the court held that prayers at a high school graduation violated the Establishment Clause because of the informal coercion involved. You know, every kid wants to go to his or her high school graduation, they have to be there, and they might feel compelled to participate. And in the Santa Fe case, it was sort of similar. This was, high school football is a really big deal. People feel compelled to go, and they have to listen to these prayers, and maybe they'll be informally pressured into joining. I think that argument makes a certain amount of sense here. I mean, I do think if your football coach is out there praying and you want to play on the team and you want to be a member and have camaraderie and all that, you might feel pressured to join in. The only problem is, or not problem, the issue here is the coercion test, that sort of informal coercion test, is very strongly associated with Justice Anthony Kennedy. And he is now retired. And it's not at all clear that other justices on the court are that enamored of this test.
Yeah, I think that's true. In fact, I don't think that they're enamored either of what Justice Scalia derided as the psycho-coercion test or of the endorsement test. So I think certainly the signal that Justice Alito and at least three other justices were sending was not only, number one, that they're willing to revisit Smith, but number two, since we're talking about the kinds of concerns that would justify the government encroaching on or imposing a burden on somebody's religion, it sounded to me like they would at least treat those sorts of reasons, the psycho-coercion reasons or the sort of kind of soft endorsement reasons, skeptically. So these two things go together, revisiting Smith and reimposing a substantial burden, a compelling interest approach, and then really kind of subjecting to some substantial scrutiny what counts as a compelling interest.
Yeah, I think that's a really important point, Mark, and that sort of brings us back to the top of the podcast, which is here we just had this seemingly offhand comment. It's one sentence in a statement concurring in the denial of cert by Justice Alito and a few other justices, but there's a lot in there, and I think it's really important. If you're a court watcher, you care about these issues, law and religion issues, you got to focus on these things, and I think you're right, Mark. I think this is pretty clearly suggesting that the court's willing to revisit these cases and also perhaps revisit these other tests too. So let's stop there. I want to thank everyone for listening again. Again, if you'd like to hear past podcasts, you can find us on iTunes, Legal Spirits, or you can check out our blog, lawandreligionforum.org. Until then, this is Marc Movsesian, the director of the Center for Law and Religion at St. John's, with my friend and colleague, Marc DeGirolami, the associate director. We'll see you next time.